if you emphasize seniority alone in the recruitment to the appellate courts, you will get it wrong. And that is one of the problems.
So if you emphasize seniority alone?
Yes. And there is a lot of emphasis on seniority. And between the Court of Appeal and the Supreme Court, there's still, in 2011, I couldn't come to the Supreme Court because the person I was shortlisted with was a senior, a PJ. Everything in Nigeria here, your right to the headship of the court is largely gerontocracy. Gerontocracy is by the rulership by age. So it is your age at the bench they consider will grow, and then the heads of court are likely to tell you, wait for your time. That is it. So because of gerontocracy, I came all the way here, so you have to wait. That breeds, that tendency can give room for autocracy. He doesn't see himself as primus inter pares. A bad one. The dialogue between Justice R.V. Ramana, Chief Justice of India, and the retiring Justice Breyer of the United States of America from the Supreme Court. It's just April, a webinar dialogue. And on diversification of the bench.
Okay, diversification of the bench.
He says it's good. The Chief Justice of India says it's good because when you bring all shades of opinion to the bench, it makes the bench richer and it gives the people the impression that it's a people's court. That if you bring a farmer's son, somebody who has a background and this and somebody who has background in commercial law, it enriches the bench. And I agree with him. We need to encourage that instead of concentrating on seniority alone. And there is another argument here, the recent circular by the CJM for appointment of justices. He invited the private bar, which I think is right. Let them come. Those of them in commercial, maritime, and this or whatever practice, let them come and reach the bar, the bench. Teslim Elias was straight.
He was straight.
Elias was professor of law, Attorney General, and he was made Chief Justice of Nigeria. Had his PhD in pharmacy. First of all, Namadi was sent to London. His father, at the time they discovered the coal in Enugu, and the litigation became very popular and all this. So they thought he was reading law. When he came back, with his PhD in pharmacy, and the father came to the airport to receive him, and he says, doctor of what? He said, no, pharmacy. And the man was not happy. That's how the boy was sent back to go and read law. And then when he came back, he was a very good advocate, and all this. Then that is PhD for you. PhD in pharmacy. In Nigeria here, Justice Aguda.
Yes.
So mechanical engineer. Aguda was in he did his year back College of Technology before he read law. And then Obaseki was in agric.
Yes, I have a degree in agric. Yes.
Okay. Then who else? You will find it's like when I find from JAMB these things that you must have literature in English and all this thing. It's not relevant for law. It's not. Lord Denning, he had his first degree in mathematics here in Yosu. He was in the science classes throughout. He was in the science classes. I was in the science classes all through.
Oh.
Though I read for my A-level, for A-level, I read English, geography, history. But I was in the science classes.
Okay, so you feel it's in order for senior advocates of Nigeria, senior members to come.
It doesn't necessarily have to be senior advocate. No, anybody very knowledgeable in this, so be it.
Okay, knowledgeable in law.
Yeah, all I need is the jurisprudence, the good knowledge of the law and this thing. Has good morals, has a good this thing. So why must we say you have to rise from this thing? I may be offending those of my colleagues.
Because they're waiting to be elected.
I may be offending my colleagues who rose from the magistracy.
Yes.
But being a lawyer on the bench, your attitude to the way you perceive certain things are different from the lawyer on the private bar, a defense counsel. The way he sees things may be different from the prosecuting counsel. And the way the two of them at the bar see things may be different from the adjudicator. So why don't we bring from the private bar, from the official bar, magistracy, even from sound ones in some good who have good practice in commercial law.
People like Abakoba have good practice in maritime law.
Yes.
Idigbe,
and all the
capital market.
Capital market, and we need them. And there are so many appeals from capital market here, from maritime and all the distance. We need them. Speaking for myself, it's not official, but the distance, I agree with him. The tendency is, I don't know why the distance. Some have had arguments that, okay, we have made a sacrifice for the nation. Yes, did they not sacrifice for the nation? Are they not contributing to the economy? Did the Constitution do that exclusion? We need this diversity on the bench. I must say, we need diversity on. My orientation is human rights jurisprudence. Maybe you can catch me if reading my judgments. That's the area. Right from this, and that is my focus. When it was that drive in arguing bail and all the this thing that even drove me to writing the law of bail. Conflicting judgments. At a point when the Court of Appeal had less than 5 divisions or about 5 divisions, the incident was not as bad. Now they have about how many divisions? 20 divisions. Then the manner of recruitment is important too. That is where the problem is. The individual judge. You are bringing in a judge because it's a hand-clapping hallelujah Christian. You are bringing a this in because it's a fanatic Muslim. Or you are bringing because it's an animist. That shouldn't be the consideration. Is he jurisprudentially equipped? Does he have enough intellectual warehouse? Because of this, we have sort of made things political. So because of that political element, oh, my brother, it has to be there. Mind you, I spent 90 years on the bench. In some zones.
That's at the High Court.
In some zones, 5 was enough to go to Court of Appeal. There it is. Then in some other, while we are talking about that, then when you go to the south, it is muzzle. Don't want to say anything more than that. So these things are, that is what the moral, the subjective element that is causing that conflicting. They are not bothered to read and distinguish.
Not bothered to read and distinguish.
The authorities. So at the end of the day, you just hand it and it is in conflict. Even the judgment, the previous judgment handed down to you by the time you go through it, you can do some distinction to avoid that conflicting. It's a human institution, and there are certain errors in human institution. Some may be deliberate, some may be innocent. The one you are talking about, if the one that is there's no society will tolerate is a deliberate error and a deliberate decision to do something wrong. Apart from that, I won't comment further on this because I was supposed to be on that panel and I was not on that panel. And I was on the panel that declared Nwosu as the authentic candidate of APC, and Hope Uzodinma was a respondent in that appeal. I was also on the panel that declared that Nwosu, having taken from zero, the candidate, having agreed to be sponsored by AA, at the time when he was also being sponsored by APC, he was disqualified from contesting it. So those two judgments at least recognize Nwosu as APC candidate. That is the much. Since I wasn't on the panel, I don't know what happened. It is completely, we've been telling them at the conferences, in fact, next week or so, or on the 17th, I'm billed to appear again at National Judicial Institute to address some judges on it.
This bill?
Yeah, on this bill. It's just, what is this? It's not there in the statute book. A stringent bail condition amounts to no bail at all. And for a judge to say you have to bring somebody who is a director. How many people from my community are directors in the federal service? These are very outrageous bail terms, and when bail terms are outrageous, it's tantamount to denial. And this is why they are still doing it. I don't know. In spite of the battles we fought in 1980s.
And they still on. This is 2022.
2022. These people who are judges at the High Court are still giving. It amazes me. It baffles me.